Okay, well, let me go ahead and kick this up. I know we probably got some people joining in, but Mitchell, I want you to have as much time as possible. First of all, let me welcome everyone. My name is Tammy Wallace. I am the co-founder and board chair for the Greater Houston LGBT Chamber of Commerce. I want to thank Katine Nechman McLaurin LLP for supporting the webinar today, sponsoring, along with our folks from the Stonewall Law Association of Greater Houston. And I want to welcome everyone that's on the call with us. I know some of you are coming through Stonewall Law, some of you are coming through the chamber. We love this collaboration. We think this is great, and just love being able to launch this type of format in a time of crisis to bring this timely information to everyone. And as I'm sure everyone on the call, the Zoom call today knows, that it is not business as usual. Webinars are the new format going forward. It is an interesting challenge for us as a chamber as we're adapting to this new online platform. So when, I reached out to Mitchell to say, hey, would you be interested in hosting a webinar for us? I love the enthusiasm, and here we are today as we again adapt to this new online format. So I'm going to just ask you to bear with us as we're getting accustomed to Zoom. We've done a handful of these now, and we get better and better with that. Just a couple of housekeeping items before I turn it over to Mitchell to get started. If you do have a question, we're going to have, there's a chat box, and that is the way we are going to monitor the questions for today. We'll have a Q&A segment when Mitchell finishes, and then we'll be sharing those questions out with him today to answer. So don't hesitate to put any type of questions again in the chat box. So with that, because I want to give Mitchell as much time as possible, let me do an introduction. And first, before I give Mitchell's formal bio, let me just say how proud we are to have Katine Nechman McLaurin LLP as one of our chamber members. The firm has been with us for a long time supporting the chamber, and we really, really appreciate that. And our presenter today, as you all would have read, is Mitchell Avila Katine with Katine Nechman McLaurin LLP. He is a founding partner with the law firm. Over the course of his career, Mitchell has not only distinguished himself as an outstanding professional with unique talents and expertise in a myriad of legal fields, he has also been a community leader and an advocate for many of the most marginalized in our society. He is perhaps best known as having served as local counsel for John Lawrence and Tyrone Garner in the landmark United States Supreme Court case, Lawrence v. Texas, which created new paradigms in U.S. privacy law jurisprudence. Mitchell, with law partners John Nechman and Neil McLaurin, handle a wide array of legal matters on a daily basis. John Nechman is an immigration lawyer and has been kept very busy, as you all can imagine, with the changing immigration laws due to the current administration. I know John is on with us. Mitchell and Neil focus on all types of real estate matters, homeowner association issues, and probate matters. Mitchell has been drafting wills and probate documents for clients for over 35 years. He started helping clients draft their estate documents during the HIV/AIDS crisis and continues to do so to this day. With that, Mitchell, I'll turn it over to you, and thank you again for presenting today. We appreciate you.
My pleasure. Thank you, Tammy. Hello, everyone. So this is the first time I'm doing a video seminar like this. I've given many seminars over my legal career. I enjoy talking with people, but also, I usually see the reaction from the people who come to the seminars, and people ask questions and do all of that. So it's a little different doing it this way, but under the circumstances, it's the best we can do. And I think this topic is particularly important because of two things. First, people are at home and can't get out to lawyers' offices. And second, unfortunately, the seriousness of the medical condition, people are scared of getting sick and of dying. And if they have not got the documents in place that we're going to talk about today, then their wishes may not be carried out. And that is really the fundamental purpose of everything we're going to talk about today is the state of Texas has passed these laws allowing us to do holographic wills, powers of attorney, and directive to physicians, which is what we're going to cover all of that today, in order to let each person, each adult, put in writing enforceable decisions. This is what they want. And if you do what we talk about here today, they should be honored and recognized by the courts and followed. Without it, many people will not have their possessions go to the people or the entities that they want. And also, if it's a healthcare situation or a business situation, we're going to talk about healthcare power of attorneys and statutory business powers of attorney. If you become ill and have to be in the hospital for a week or 2 weeks or 3 weeks or longer, you want, and you're not able to make your own medical or business decisions, the documents we're going to look at today will help you decide now, while you're well, who will make those decisions for you if those unfortunate circumstances should arise. You know, the HIV/AIDS crisis lasted 10 or 20 years. It was terrible, where people were dying. And a lot of this reminds me of those periods of the 80s and the 90s. And the things that we're talking about today, having wills and powers of attorney, are basically the same type of instruments. They may have changed substantively, but they were just as important back then as they are today. The one thing that's a little different is we now have the ability to get married, as I have with my partner, and many people have gotten married. And so we're going to talk about the situation of marriage, same-sex marriage, opposite-sex marriage, just marriage, and how that might affect these situations as well. Often without these documents, if you're married, that is helpful. If you're not married, these documents are even more important. But as a bottom line, everybody should have a will. It is preferable and recommended that people go to a lawyer and have a proper will drafted to avoid mistakes, misunderstandings, and having their will, to avoid having their will not honored if they've done something wrong. And we're going to talk more about that today. So it's also important for you to know that as a lawyer, I'm giving some general legal concepts today, telling you I'm going to show you some statutes and some sample documents. We're going to actually help you write a holographic will today in our time frame. We're going to go sentence by sentence. So if you can go grab some paper and a pen, you're going to, if you don't have a will and you want to write a will, you will be able to write a valid legal will today before 3 o'clock. And when we're done, you will have a will that will be legal, that will be within the formalities if you follow the instructions that I'm going to give you of the law of the state of Texas. But it's important to know that I cannot give legal advice to each person on their situation. You should talk to a lawyer. If you need a lawyer, you can call us. We're happy to help you, or call another attorney who does estate planning documents. And so it is recommended and best for everybody to have their documents prepared by a lawyer. Okay, it's generally not that expensive. It's not that difficult. Get it done properly. During this hopefully temporary period of time where you can't get to a lawyer's office, where you can't execute documents with your lawyer, with a notary, what we're going to talk about today is the next best thing. It's better than not having anything. Okay, holographic wills are valid. They're better than not having anything, but I want you to know it's always best to have a proper statutory will drafted by an attorney. It's also important for you to know, I don't know everybody that's online, but the information that I'm going to give you today is only for people that reside in Texas. Every state has their own laws, and they may not be the same as Texas. If you reside here, that means you have a driver's license, you're registered to vote here in Texas, then the things I'm going to talk about today are relevant to you. If you're visiting, if you happen to be seeing this like in Florida or New York, do not listen to what I'm saying because this does not apply in other states. In fact, my brother-in-law, I asked if he could make a holographic will, and I thought, oh, sure, Florida has holographic wills, but I then went online and saw that holographic wills are not valid in Florida, according to what I saw on the internet. So that shocked me. I thought Florida would be similar to Texas, but it's not. So what we're going to talk about today is only for people in Texas. On the first page that you're seeing, Exhibit 1, that's my resume, that's my background. There's my contact information, my email, my phone number. Feel free to call me, especially after this seminar is over. If you have a question, you want to talk to me, but anytime. Honestly, we're not very busy because of the virus situation. So call me, call another lawyer. We'll all be happy to help you. Okay, so there's my resume. We're going to continue on. Let's go to Exhibit 2. Exhibit 2, there is the accreditation number. Thanks to Stonewall Law Association for getting this accredited. Right in the middle, it says course number 174083183. After the seminar, you're going to need to go online, and if you're an attorney watching this, go online, get yourself the 1-hour CLE credit, and we're thankful for you to do that. Let me see if I have any more information before we actually get started. As I told you, it's important that your wishes get carried out. And the way you do that is by having documents drafted by yourself, as you're going to see today, and you put in there what you want. I'm going to give you more information about that in a moment. I do want to let you know that here with me in my office today, 6 feet away from me, is Stephanie Alvarez, who is another attorney with our firm. And one of the things that she does that's kind of unique is she helps people probate estates when they don't have a will. And that's what we're going to look at first, is what happens if you don't have a will. What does the law say? Also with me is my legal assistant, Valerie, another 6 feet away, and she works with me with clients in helping to draft documents and getting the decisions from the clients as to what they want, putting them down on paper and getting them signed. So let's go to the next slide, which is Exhibit 3. If you don't have a will, that's called intestate succession. And Stephanie, I want to tell you, if you hear something that you disagree with, you jump in and get me corrected on that. Okay? So this is, and all of these statutes you're going to see, I took from the Texas Estates Code, which is right here. This is a great video. This is the Texas Estates Code. And all of these statutes, you can go online, put in section 201.001 of the Texas Estates Code, and you will see this. I'm starting with this because this describes what happens if you do not have a will. That's what intestate means. And if you look at this, the first thing it says is, the person's estate descends and passes to the person's children. The first one, 001, is not leaving a spouse. Let's talk about that for just a second. There are two basic ways that you have a spouse in Texas. The one way is that you get married. Now, you can go down to the county clerk's office and get a marriage license and have a ceremony and file it and sign it, and you are now married. Another way that you can be married is called common law marriage in Texas. or informal marriage. Stephanie is also a family law attorney. She works closely with me on marriage issues, adoption, and divorce issues, and prenuptial agreements, things like that. So now all adults can get married. In order to have an informal marriage, you need to have an agreement with the person to be married, hold yourself out to the public, third parties, as being a married couple, and live together. There's no time period in which you need to live together. It can be a short period or a long period, but once those three elements exist simultaneously, you are now married. Stephanie, did I do it correctly?
Absolutely.
Okay.
Got it.
So those are the elements to be married. Once you are married, you can't just break up like we used to do before marriage was legal for gay people. You have to get a divorce. You have to go to court and have a judge grant a divorce, whether you've been what I'll call formally married with a license and a ceremony, or informally married. So a lot of the probate matters that we're going to talk about today, we're going to talk about community property and separate property. Those type of things are based on whether you're married or not, informally or formally. Once you're married, either way, you are married, and the laws of dealing with spouses and community property, Texas is a community property state, apply. They're both of equal weight, whether you're formally married or informally married. The point is, are you a married person or are you not a married person? I also want to remind you, you can only be married to one person at a time. So if you get married, either way, you have to get a divorce in order to have a valid second, third, or fourth marriage. You can't be married to two people at the same time. Okay, everybody got that? So now let's look at what happens to your property if you don't have a spouse, okay? First, the person's estate descends and passes to their children. Some people have children but are not married. Next, if you don't have any children, then it passes to your father and mother. If there's only one father or one mother, you only have one surviving parent, half of your property goes to the surviving parent, the other half goes to the person's siblings, brothers or sisters. So I'm going to let you look at the rest of that. I'm not going to go through it. It'll keep going to your descendants, depending on your personal situation. The next is, if you are married. If you are married, just like in a divorce, when you die, you have to divide up your property between what's community property and what's separate property in Texas, okay? Separate property is what you own before you get married, or that you've received as a gift, or through inheritance, or also, I think, through a personal injury settlement.
You got that right.
Okay, so that's separate property. Everything else, all your income, everything you buy, everything from the date you're married, either informally or formally, is presumed to be community property. And when you have community property, Stephanie, we're 50-50, right? Presumed?
It's a just and right division to be, yeah.
Okay, a just and right division of the community property. Separate property is not divided. Separate property belongs to the person who it is their separate property.
Correct.
So things like, after you're married, putting property in one spouse's name or the other, it's still community property. Money that you earn by yourself after you're married, that's still community property, and part of it is presumed to belong to your spouse. So it's important in Texas to determine what's separate and what's community. And so let's look at if you die without a will. And so when we get to the will part, the only thing you can leave in your will to whoever you want is what you own. So let's presume a just and right division of your community estate is 50-50. If you own 50%, you can only give 50% under your will. You can't give away property that's not yours. The other 50%, I'm presuming a 50-50 split, belongs to your spouse when you die. So that's important. So let's look at 201.002 that's on your screen. And this is what happens to your separate property if you have a spouse. And what they do divide up is, and this has to do with children, not children. If you have children, the surviving spouse takes 1/3, and this is of your separate property. Without a will, the surviving spouse takes 1/3 of your personal estate versus real estate, your personal property. 2/3 of the personal estate ascends to the person's child or children. So 1/3 to your spouse, 2/3 to your children. The surviving spouse is entitled to a life estate in 1/3 of your land and the remainder to the children. If you have no children, the surviving spouse is entitled to all of your personal property. The surviving spouse is entitled to 1/2 of the person's land without a remainder, and 1/2 of the person's land passes and is inherited according to the rules of descent and distribution. Okay, I know this is complicated. That's why we want everybody to have a will so that you can decide what happens to your property. One more, let's go to the next slide, 201.003, the community estate. Remember, the community estate is your half of the community estate. The community estate of the deceased spouse passes to the surviving spouse if there's no children or other descendants of the deceased spouse survives the deceased spouse, or all of the surviving children and descendants of the deceased spouse are also children or descendants of the surviving spouse. This gets really complicated and a lot of times shocking to people when you have stepchildren. When your spouse has children prior to your marriage, they have a right to some of the community property right here. If the deceased spouse is survived by a child or other descendants who is not also a child of the decedent or child or other decedent of the surviving spouse, the deceased spouse undivided 1/2 interest in the community estate passes to the deceased spouse's children or other descendants. So if I understand this right, Stephanie, the stepchildren get a 1/2 interest of your community estate, okay? So for a lot of people, they want sometimes they do want their children from a prior marriage to inherit. Sometimes they don't. That can all be solved by making a will. So let's talk about that. Well, in a moment. Let's go to the next slide. Before we get into who may make a will, I want to make sure everybody knows that there are certain assets that don't come under a will. What that means is your bank account, your retirement account, your investment accounts, your life insurance, all of those things that have beneficiary designations go outside of your will, okay? Unless you designate your estate or no designation is made or whatever. If you want it to go under your will, put into my estate or to my executor for my estate. But most people prefer that their beneficiaries be designated, even if it's the same person who's going to inherit under your will, because it goes directly to that person. There's no probate, there's no delay. You give a death certificate to Merrill Lynch or Charles Schwab or your company and or the life insurance company, and they pay pursuant to the beneficiary designation. So you want to make sure that all of your beneficiary designations are updated and kept up to date so that those assets go directly to the person who you want to receive that. Another important benefit to beneficiary designations is, generally speaking, the creditors, because under your will, before you distribute your assets to the people you designate in your will to receive it, you have to pay all the debts of the estate. Medical bills, credit card bills, mortgages, whatever bills you have, they have to be paid before your executor can distribute your assets under your will. Beneficiary designations don't have that requirement. They will pay out directly, immediately upon the death, and there is no payment to creditors first out of those beneficiary designations. There's also one other thing that's available under Texas law, and that is, if you are a co-owner or joint owner of property with someone, you can reach a written agreement. It's a very simple agreement to hold that property as joint tenants with rights of survivorship, which means that if one person dies, the other person automatically gets the whole thing. Doesn't have to go under the will. It's an automatic transfer of ownership, kind of like the beneficiary accounts. But it has to be in a separate written and notarized agreement, has to be signed, notarized, and recorded in order for you to have joint tenancy with right of survivorship. I believe this now applies to both community property and separate property. There are so many other things. There's a death in anticipation of, there's a deed in anticipation of death, many other things. We don't have time for everything today in this seminar. So if you have questions or you want your particular situation to be given consideration, make sure you talk with an attorney to discuss your facts. Again, I can't give legal advice on all the individuals and all their fact patterns. I'm just giving basic information. All right, let's talk about a will. We finally got to the main subject of today's seminar. What is a will? A will is simply a document that does two things. Number one is it says, who do you want to get your stuff when you die after your debts are paid? Uh-oh. Sorry, my light went off a second. All right, there we are. It's on a timer. So first is, who do you want to get your stuff when you die after your debts are paid? And number two, who is going to be in charge of carrying out your wishes? That's it. That's the big deal. In Texas, it can be very simple, as you're going to see today. Probate is not complicated. It's not expensive. I am not a fan of trusts. A lot of people want trusts because they're afraid of probate. Probate is simply filing the will with the judge and have the judge look at it, have it proved up. I'm going to show you what you need to prove it up. Now, a lot of these prove up hearings are less than 5 minutes. I know Judge Jerry Semino, Probate Court 1, has something called Rocket Docket, which I've done, where we go in and it literally takes 2 minutes. Everything's online, everything's approved in advance. As long as it's done properly, probate is easy. You have one hearing, 5 minutes or less, and that's the only time you have to go to court. And then you file an inventory, you take an oath, you do all these things that are not very difficult. Most probating of wills cost, legal fee wise, between $2,000 and $3,000. This is presuming there's no contest and no difficulties. $2,000 to $3,000 in Texas for a properly drawn will, and probate is usually all it costs. Wills don't have to be expensive either. What I'm trying to tell you is that people are afraid that this process is complicated and expensive, and it's not. It's simple, it's easy, and it's inexpensive. Different lawyers charge different things. We do not charge very much money to do the whole 8-document package. I don't know what other lawyers charge. Check with lawyers, find out what they charge, but most people try to make this economical and easy to do. So you now know what a will is. I'm going to tell you how you do it. There's statutory wills and holographic wills. Who gets your stuff and who handles it? It is important sometimes for you to for the determination of what is your current will, because the current will controls. And when you make a new will, like we're going to do today, that invalidates older wills. Now, if there's a problem with your current will, let's say it's not valid, you never signed it, then it'll go back to your other will, unless you have terminated that other will. The best way to terminate your will is tear it up. You tear it up, you've invalidated it by that physical act. So if you don't want that will to be valid anymore, tear it up. As you're going to see when we prepare the will in just a few minutes, your holographic will, most wills say, this is my current will, and all prior wills are hereby, let's see what I put in mine, declared invalid or void. Oh, and revoke all prior wills. That's what we say. That's what we're going to say when we get to it. All right, let's move along here. You have to be under this slide, you have to be 18 or married or a member of the military to make a will, okay? So that is the first requirement. Let's go to the next slide. Under section 251.051, will requirements. First of all, it needs to be in writing, and it needs to be signed by the person making the will or another person on behalf of the testator. The best thing is the testator signs it, okay? So those are your first 2 requirements. In writing, that means in writing. Now, in writing could be interpreted as typed or handwriting. So we're going to talk about handwriting in a minute, but it has to be in writing and signed by the testator. And you can have another person do it, but I wouldn't recommend that. And another requirement is 2 credible witnesses who are at least 14 years of age who subscribe their names to the will. Now, those 2 witnesses are basically for a statutory will, because as you see in 251.052, a written, a written will wholly in the testator's handwriting is not required to be attested by subscribing witnesses. So the holographic will we're going to make today is going to be entirely in your handwriting, and it's going to be signed by you. No witnesses, no notary, nothing else. It's going to be in your handwriting and signed by you. Let's go to the next slide. Some other fundamental things. First of all, a will is not valid until it's probated. Probated means you go to court, a judge reviews it and admits it to probate, signs an order, says this will is proper. Also, the probating of a will of a living person is void. Okay? A person has to die for you to probate a will. If you want to record the will just for safekeeping, you can do that down at the county clerk's office in the probate department, and they'll record it for you so that it's there if and when you ever die. But most people don't do that. I just want to let you know it's available. The next thing, not the next slide yet, but the next section says you have 4 years to probate a will. So after someone dies, there is a 4-year period to probate the will. That's section 256.003. Now, if you have a will and it was not probated within 4 years, there are still some things we can do. It's called a probating of a will as a muniment of title. And that is something that judges and the courts allow you to do primarily to convey title to property. It's a little different, and that's why I'm saying if you have a situation, a probate situation, a will, or you want some advice, talk to a lawyer because there may be exceptions to these. I'm giving you the general rules. And the general rule is you have 4 years after a person dies to have it probated by the court. You should also know a will contest. A will contest is where someone challenges the validity of a will. You have 2 years to file a will contest after a will is admitted to probate. So 4 years to probate the will and 2 years for somebody else to contest the will and say it wasn't valid. There are 2 things that are primarily used to invalidate a will. First, in order to make a will, you need to be competent, which means you know what you're doing. Okay, you know what your assets are, you know who your family is, and you know what you're doing. The second is you have to make those decisions in your will on your own choice. You're not being unduly influenced by a third party to leave your stuff to them. So those are the 2 major grounds that wills are contested, that someone was so sick or in such bad shape they didn't know what they were doing, they weren't competent. And number 2 is somebody kind of took over their life and pressured them into making a will that they did not really want to make. Those are the 2 grounds. Okay, let's go to the next slide. In order to have a will admitted to probate, you have to have somebody come to court and say the person has died, it's not been 4 years, they lived in Harris County or whatever county you're probating it in. You probate a will in the county where the person last resided at the time that they died. Okay, there's a citation, the court will post a citation, and the person who is the executor, the person who's in charge of your will, of your estate, is called the executor for a man and executrix for a woman. Additional proof: the testator did not revoke the will as far as you know. If the will is not self-proved, then if the will is not self-proved, the testator executed the will with the formalities that are required. And at the time of executing the will, the person was of sound mind, was 18, was or had been married, was a member of the armed forces. Let's go to the next one, slide 10. So let me first tell you, a holographic will is generally not self-proved. Self-proved means you've attached an affidavit to the will. So you have the will and you have a separate affidavit that basically says that the person who made the will was of 18, they were of sound mind, there were witnesses, and everybody was in each other's presence, and everybody signs the affidavit before a notary, and the will is now self-proved. I want to share with you that there is a procedure, which is on your screen, to self-prove a holographic will, which is what we're going to make in a minute, by attaching an affidavit to it. The affidavit is separate from the holographic will. I've actually never seen this done. And again, I was talking with Judge Semino yesterday, and he says he's never seen this done either, but we're all aware that it could be done if we wanted to do it. All right, next slide, 11. How do you prove up a holographic will? The same things that we talked about before. You have the applicant come and testify as to the competency of the person, but there's one extra requirement, and that is you have to have 2 witnesses come to court. Oh, let's go to the next one. Let's go to the next slide. No, let's go back to the other one. Okay. Well, I got a little confused here. Let's go back to number 10. Sorry, these were out of order. Number 10 slide, 256-154. This is how you prove up a holographic will. You have 2 people come to court and testify as to the handwriting of the person who made the will. That's you. You're going to make the will today, and you have 2 people after you die come to court and say, I swear I'm familiar with their handwriting and this is their handwriting. Next slide, number 11. There is a way to do a self-proved holographic will. That's on your screen. I've never seen it done before. I'm just letting you know it's available. Next slide. If you know there was a will and it's been lost, okay, you should keep wills in a safe place and let the executor, the person who's going to be in charge of your will, know where it is. But let's say it gets lost or destroyed. You can still probate a lost will. These are the requirements. You have to be able to tell the judge what the will said, so you had to have read it. But I want you to know, if there was a will, if you're sure there was a will and it's been lost, you can still go forward. All right, does everybody have their piece of paper? Their blank piece of paper? Get a pen. I prefer a blue pen, but if you have a black one, that's fine. I have about 15 more minutes, and we're now gonna write your own, you're gonna write your own holographic will. You ready? All right, so at the top of the paper, write last will and testament. Okay, just like me, I made a holographic will here just for this seminar. Last will and testament, write it at the top. Next page. I, Mitchell Katine, make this my last will and testament and revoke all prior wills. Now, you don't put I, Mitchell Katine, because that's me. You write your own name. I, Janet Jackson, or whatever. You write your name and write this sentence. That way you are letting people know this is your will. A will is your actual testamentary document. This is not a desire to make a will, or this is what I want, or this is what I wish. All of that language is bad. You need to make a will that specifically says, this piece of paper is my will. Next slide. I hereby give my entire estate to, now Walter Avila is my spouse, my partner, so that's what I put. If you want to leave your entire estate to one person, then put their name right in there in this sentence. I hereby give my entire estate to blank. There are some other options. Next slide. Let's say you want to divide it between two people. Like, instead, I could put, I hereby give my entire estate to my sisters in equal shares, share and share alike, or to the survivor thereof. That means if one of them dies, then the one that survives gets everything. They also share it 50-50. Let's go to the next one. Both of my sisters have children. So if one of them dies and you want to leave it so that their children inherit their share, you use the term per stirpes, just like I put on my slide here, 17. That means I leave it to my sisters equally. If one of them dies, their children inherits their half. Let's go to the next one. So this is where you can leave a specific bequest to one person and then have your remainder estate go to them. So if you have something that you want to leave to a person, like your car or a piece of real estate or some jewelry, the most important thing is that you describe it very clearly so that a stranger knows what you're talking about. I like to attach pictures to wills when it comes to jewelry. So this is that alternate. Okay, let's go to the next slide. Number 19. You have to appoint an independent executor or executrix to serve without bond. And it can be the same person that you're leaving your entire estate to, just like I did. I'm giving my entire estate to Walter Avila, and I appoint Walter Avila to be my independent executor, to serve without bond. Serve without bond means you're telling the court that you trust this person and they don't need to put up a bond. Let's go to the next slide. Okay, here's a sentence that will help the judge know that you're going to have an independent administration. Write what's on the screen. No action shall be required of my independent executor in any court other than the probating and recording of this will and the return of an inventory and list of claims if required. Okay, that's some technical language that tells the judge that you're going to have an independent administration. You still have to go to court, get the will approved and admitted, and then you just follow the law. Next, if you have children and you want to add a provision of guardianship so that, you know, let's say you don't have a co-parent, you're a single parent, you have your kids, and you want to have a guardian appointed, you can add that to your will as well. Next, if you want to direct how you want your body to be handled after you die, you can add that too. These are optional provisions. They're not required, but you can do this. You can make your will 1 page, 2 pages, whatever you want. I would have you sign every page, though, as you go. Next page. As you can see at the bottom of Exhibit 23, you have to sign it. That is my will. It is wholly in my handwriting, and it's signed by me. Next page. There's today's date. Dates are not required, but they're helpful to know which order your wills are. Remember, the latest dated will controls. And so this is it. You now have your will. And again, I recommend you have a formal will done by a lawyer when this crisis is over. But you now have a valid will that you should keep safe, and let your executor know that you have this will. So if God forbid something should happen to you, you now have a valid will that can be probated in Texas and Harris County, and your wishes honored and followed. I'm going to quickly go over a couple of other documents. These are documents. Go to the next slide. This is what Texas calls a living will. It's called a directive to physicians. This is the document, and all of the documents that I've included here, I just printed off of the Texas Medical Association. You can go online to the Texas Medical Association and put in advanced directives and fill these documents out. The first 2 do not need to be notarized. The last one does. These just need to be witnessed. This one is Texas's version of a living will. This says to the doctor, if I'm going to die, if my death is imminent, once you have determined that, and if I have a medical power of attorney in conjunction with them, you can let me go, keep me comfortable, let me pass away. I don't want to be kept alive if my death is imminent. So we're kind of, let's go to the next page of this. This is page 2. As you see in the middle, it says, if a medical power of attorney has been executed, then an agent has already been named and you should not list them here. The medical power of attorney is the next document I'm going to show you. But if you don't want to do that document, you can list the names of people who will make medical decisions for you if you are unable to make them for yourself. This document, this directive to physicians, also known as a living will, does not need to be notarized, just witnessed. Oh, Barry, I just got your note here. The will that I have just described to you, Barry wanted me to make sure everybody knows, do not type it up. Do not type it. That will invalidate your holographic will. It has to be in your handwriting, okay? We're going to talk about notarizing and witnessing in a minute, but the holographic will has to be in your handwriting, has to be signed, preferably dated. No witnesses, no notary on a holographic will. Okay, you can do the self-proving affidavit. Most people don't, but that's separate. Let me continue on, and then we're going to do questions real quickly. Page 20, let's go to 27. Exhibit 20, go to 28. This is the medical power of attorney document from the Texas Medical Association. You see at the top, they find this in the Health and Safety Code. You can fill this out by hand. You can, this is if you can't make medical decisions for yourself. This document authorizes your doctor to get instructions from your agent. The agent does not need to sign this. Go to the next page. Go to page 30, slide 30. Right now, it might be hard to notarize it. This document does not need to be notarized. It can be witnessed by two people. Next page, 31. This is where you sign it and two witnesses sign it. The next document, page 32, this is also provided by the Texas Medical Association. This is the statutory form for the business power of attorney, the statutory durable power of attorney. It is a little more complicated. You have to go paragraph by paragraph. You have to initial things, cross out things. It's you know, this is something that I spend a lot of time with my clients filling out. I wanted to just give you this. It does appear it needs to be notarized. Continue on with the slides. Let's, I want to get to questions. We're almost out of time. I do want to go to slide 38. Slide 38. This is something that Governor Abbott has done. And he has said normally it is required that for a notary to notarize your signature, you have to be in the presence of the notary. Governor Abbott has issued this executive order that says, let's look at the bottom, that a notary can notarize a document through video, like we're doing right now. I see a question, can you use a holographic will for your business? It can be for anything you own. A holographic will is not limited to assets. It can be your real estate, it can be your jewelry, it can be your business, it can be for whatever, okay? Let's go back to this, the notary. At the bottom, let's look at this. The following conditions will apply whenever this suspension is invoked. Number one, a notary public shall verify the identity of a person signing a document at the time the signature is taken by using a two-way video or audio conference technology. So just like you can see me, you can do that. Thank you, Jessica. Let's go to the next number, 39. A notary public may verify identity by personal knowledge of the person signing. So if I know you, that's good enough. Or by presenting your driver's license, a valid driver's license or passport with a picture and a signature. And the last thing is the signing person shall transmit by fax or electronic means a legible copy of the signed document to the notary public, who may notarize the transmitted copy and then transmit the notarized copy back to the person signing by fax or electronic means, at which point the notarization is valid. This order is expected to, this says, until it terminated by the office of the governor or until the March 13th, 2020 disaster declaration is lifted or expires. I think that's been extended to the end of April. Good, Ceci, good thing. A listener wanted to know, can you designate alternates? Yes, alternates. I didn't do that because I tried to keep the holographic will as simple as possible, but you can put alternates in. If you say, I leave everything to Walter, but if Walter should pass away before me, I leave it to my friend or my whoever. You can list alternates in your documents. Tammy, we only have a few minutes. I do want people to know, if you have a question after this is done, call me. I'll be here all afternoon. You can call me at 713-808-1001, 713-808-1001, or send me an email and I will try to respond to you free of charge, just so that we can all get our documents in place until this crisis is over and then go have go have formal documents made by a lawyer. Tammy, let's see what other questions I may have missed.
I think you've caught all the questions up until this point, unless anyone else has an additional question. We got some notes coming in. Some very kind notes.
I hope this has been helpful. It's been my honor. The saddest thing happens is when I get a call from somebody who says, my partner of 20 years just had a heart attack and died, and his parents are at the door. I'm not on the deed. There's no will. What do I do? And I'm not married. There's not a lot I can do. What I can do is what I'm doing right now, and that is telling you to make a will. If you don't have a will, or your partner doesn't have a will, or your spouse doesn't have a will, you are in jeopardy. Get a will made, because I may have to tell you there's nothing I can do to help you, and you're going to have to get out of that house. So I hope this was helpful. Please keep in touch.
Mitchell, we did just have a couple of questions. If I already have a lawyer drafted will and want to change something, can I cross out and change something in writing?
Do not do that on the lawyer prepared will. You can make a holographic codicil, okay? You can say, I have a will dated such and such, but I want to change paragraph 3.4. I want to, instead of leaving everything to Johnny, I want to leave everything to Susie. You can make a holographic codicil to an existing will. You can also make a holographic codicil to a holographic will. That's called a codicil, okay? Good question. What else?
I think that catches the questions up until this point. And I will say a lot of thank yous. And let me say on behalf of the Chamber, Mitchell, we really, really appreciate you. I know it took some time to put all these materials together. So thank you. It's timely during this crisis to have this kind of information. I know for a lot of people on the phone, they're going to leave this and have more information than they had before. Information is vital right now. We appreciate you so very much. I also want to say thank you to the Stonewall Law Association of Greater Houston for partnering with us. Deb, we appreciate y'all. Thank you so much. And to everyone on the phone, on the Zoom, thank you again for joining us. We will be sending this out via email, including the presentation and the recording.
Thank you very much for the opportunity.
You bet. You bet. Thank you so much, everyone. Have a good afternoon.
Bye, everybody. Stay
Bye-bye.
safe.